Okay, once again, welcome to today's webinar. Today we are talking about the topic prenuptial, postnuptial, and cohabitation agreements. My name is Melissa Rosenberg. Just give you a quick intro of to who I am. I'm actually a licensed therapist, and I work specifically with one of my specialty areas is working with clients who are dealing with various stages of the divorce and separation process. And so I definitely work with clients who are at the onset of trying to determine if that's the right path for them, or clients who are in the middle of complicated legal situations and family law cases and the emotions that are tied up in that. And then also with clients who are on the other end of their case and just trying to kind of build their next path forward and navigate some of those challenges. So that's who I am. But today I'm here as a moderator for this webinar. And I'm going to introduce you here to Michelle Dellino, who's going to be hosting. And just to give you a little bit of information about how this will work. Michelle's going to deliver a lot of great information about this topic. If you have questions that come up during this course of this meeting, please go ahead and ask them via the Q&A. And if you put them into the Q&A, please note that there's an option of asking them anonymously. And if you don't ask anonymously, your name will pop up and other people on the call will see your name. So either way is fine. You're welcome to ask questions either anonymously or with your name, but go ahead and do that during the Q&A tab on the bottom of the Zoom screen, and we'll try to answer as many of those questions as we can during the webinar. So again, thank you for being here, and I'll turn it over to Michelle.
Hi, thanks for being here. I'm Michelle Dellino. I'm the owner and managing attorney of Dellino Family Law Group. We are a full-service family law firm. We serve all of Washington State, actually, and we have offices in Seattle and Bellevue. But again, we kind of go everywhere in Washington. So as we get started, what I'm going to do is I'm going to tell you first, we're going to, just so you have an idea of a roadmap of what to expect. We're going to talk about 3 different types of agreements. And then we're going to talk about validity of agreements and how anybody can draft an agreement, but not any agreement is going to be valid. And then we're going to talk about common issues with agreements. We're probably going to talk about some other things too, but those are some things I definitely want to hit on. And like Melissa said, if you have questions that you want answered, this is a good opportunity to put them out there. I do need to let you know that I'm an attorney, but I'm not your attorney. So we don't have an attorney-client relationship, and anything that you ask in this webinar can be seen or heard by other people. So if you want to ask questions anonymously, this is a good opportunity to do that through the method that Melissa described. Also, anything that I tell you is informative only. It's not meant to be legal advice. If you want very specific questions answered, we might not be able to answer those. I will try to answer a lot of general questions, but if you want like a specific analysis of your situation, I encourage you to get it and to do that through a consultation, whether it's with me or any other attorney, but get information specific to your case. So appreciate you being here. Look forward to hopefully giving you some helpful information. So the first thing I want to talk about is 3 different types of agreements, because there's multiple people on this webinar and you might be here for different things. The most common agreement is a prenuptial agreement. So what is a prenuptial agreement? We'll get into the details, but let's just talk about that and how that differs from a postnuptial agreement. A prenuptial agreement is an agreement where decisions are made by the parties to the agreement about how their assets and debts and other financial issues will be resolved should they get divorced. Those things are decided in advance before you ever get married. That is a prenuptial agreement. It's a binding contract. A prenup or a postnup is actually a contract. It's a legal contract that you are entering into. A lot of people don't really realize this, but marriage is a legal contract that you're entering into with another person, and all you really did was have a party and invite some people, or maybe you didn't even do that, and say a few words, and all of a sudden you're legally bound to this person financially for a long time. So hopefully. So a prenup is meant to be executed before you get married and to determine what are the rights and liabilities of the parties if we get divorced, if we don't want to just follow what the laws in the state of Washington are. Number 2 is a postnuptial agreement. Postnuptial agreements aren't as common as prenups, but they are equally as effective if they are properly executed. A postnuptial agreement does all of the things a prenup does. It determines what are the rights and liabilities with respect to separate property, community property, spousal maintenance, all the financial issues that you deal with in a marriage, and those are determined. And by doing that, you are able to, same way with a prenup, you're able to save yourself a lot of time and money if you get divorced later, not having to go through a process where absolutely everything is negotiated. The difference, though, with a postnuptial agreement is when you execute it. A postnuptial agreement is always going to be executed postnuptial, after your wedding. So sometimes, and some people will ask me, when can I do a postnup? Can I do one when I've been married for 20 years? Sure. Can I do one if I've been married for a month? Sure. It doesn't matter when you do it. A lot of times people will do a postnuptial agreement because they decided to do a prenup and it got too close to the wedding and they want their agreement to be valid. And one of the basis for undermining or invalidating a prenuptial agreement is closeness in time to the wedding. We'll talk about that in a bit. So sometimes people might start negotiating it before they get married and then execute it as a postnuptial agreement afterwards. So that's one thing to know. The last kind of agreement I'm going to talk about today briefly is a cohabitation agreement. And a lot of people don't even know that they might need this. They don't even know that it's a thing, although they are becoming more and more common and actually more and more useful as time goes on, especially in Washington state. So a cohabitation agreement defines the rights and liabilities of parties when they are living together and cohabitating and are unmarried. And living together and cohabitating in Washington has different legal implications than it might in other states. There can be community-like property that attaches, so this is a really important way to deal with that. So those are really the three types of agreements that we're going to deal with. So first of all, I'll just start when I talk about prenups. One thing you need to know, and this is not meant to deter you, I'll tell you first right off the bat, why do I like prenups? I don't like prenups because I think people are going to get divorced or because I want people to get divorced. I like prenups because I'm a divorce lawyer and I see people spend literally tens of thousands of dollars, not to mention the emotional turmoil of a divorce in undoing that very binding legal contract that you entered into when you had a party and got married. People might think that divorce attorneys want you to spend a ton of money and have your case go on forever. We actually don't. It's stressful for us too, to see you in that situation and help you navigate it. And we always want you to have a quicker, better, more certain resolution, number one, so you can move on with your life. And number two, so we can help you do that in a way that is less stressful. So we want you to have an easier time getting divorced. And I see my clients that have actually valid prenups or postnups get divorced and spend a fraction of the cost, have a fraction of the stress, and move on in a lot better manner. However, there are a lot of stigmas attached to prenups, and I speak especially more so prior to the last 10 years than we've seen, or a lot of people will have the misconception that I don't need a prenup, we don't have anything. Well, that might be true, but a prenup isn't about just what you have when you get divorced. For some people it is, because you're bringing in a lot of things that you want to protect. For other people, it's about what you're going to have during the marriage. That's really what it's about for everybody, and a lot of people don't realize that. It's about what's going to happen with the money you do earn or that you earn over the next 20 years. What's going to happen when you get those stock options? All of those things are really what it's about. So it's less about what you have right now for some people and more about what you're going to have. But anyway, prenups in general are what I tell people that smart people do, because just like you don't drive around with car insurance because you think you're going to hit someone. You do it so it doesn't financially decimate you if you do. You don't get a prenup because you think you're going to get divorced. You do it so it doesn't financially decimate you if you do. It's also something too, and the data does bear this. I'm not going to give you a bunch of references and statistics, but I can tell you that the data bears that couples that sit down and actually do a prenuptial agreement actually have a higher chance of not having a marriage fail in the first 10 years. And the reason why is because you've had the difficult decisions about how we're going to handle finances, what our values are as far as that goes. And those are issues that sometimes can really cause a marriage to blow up later. And a lot of people don't talk about that when they're in love and they're getting married and they're planning this big thing and whatever. They don't talk about that, and they probably should. So when you have those difficult conversations as part of a prenuptial, you are aligning on them and you're really taking that stressful issue out of your relationship. So the last thing I'll say is if someone says, oh, why are you doing a prenup? Like that's, shady or whatever. It's actually not. It's what mature, responsible adults do as a sign of love and trust to one another to say, we're going to decide how we're going to divide things. If things don't work out, we're not going to let a court decide and we're not going to waste the money that we've acquired. So that's my little, high-level overview on why they're not a bad thing. And like I said, you'll save time and money. Here's the first thing to know. Washington courts disfavor prenuptial agreements. They don't like them. And it's not just Washington. It's really most states. It doesn't mean you can't have a prenup. Many, many people do. But it means that there are specific laws that allow people to enter into one, and they have to be careful about doing it and make sure it's valid. So it's not just like you could write down, like there's some kinds of agreements where I could take a napkin and I could write down the terms of the agreement, everybody could sign it and it might be binding. That's it. There's ways you could do that in a general contract. There are specific ramifications for a prenuptial agreement, and the court wants to make, Washington legislature wants to make really sure that people are careful with it. So they disfavor it because it affirmatively allows you to alter the marital rights and duties that you're afforded under the laws of the state of Washington through a contract. You're actually altering those rights and duties. So they want to make really sure. So the courts have basically, through a series of legal cases, outlined a framework for analyzing prenuptial agreements in Washington state. That analysis is detailed, and I'll go through it in the nuts and bolts of it. But the long and short of it is that Washington courts disfavor them, and they will often refuse to enforce them if you don't do everything that you need to do in making sure it's valid. So I've had people where they're like, oh, I downloaded this from LegalZoom or some other such website, and I just want you to look at it and certify it. I'm never going to do that for you. No reputable attorney is going to do that for you because your agreement's probably not going to be valid. So no one's going to want to put their name on something and have you waste time and money on something that's not valid. So anyway, let's talk about why. The court's main concern with prenups is that they're offered and entered into really hastily. I've seen this in my own practice. And the financially disadvantaged spouse really doesn't know what they're signing. And the financially disadvantaged spouse only signs it because they feel like, if I don't sign this, we're not going to have that wedding. And then we're going to have to tell everybody we're not getting married. And it's going to be embarrassing. And, they don't understand it. So inequities resulting from the stereotypical, and this is an image that isn't really, I don't think, valid anymore, but basically the inequities of a sophisticated, wealthy man who is a primary breadwinner taking advantage of someone who's going to be a stay-at-home parent. That's the kind of situation that courts are trying to avoid. And, it could be the other way around too. It can be a working woman and a man, not whatever. It's not gender specific, but that's the idea. And courts want to avoid a situation where it's a week before the wedding and someone's like, you need to sign this or we're not getting married next week. If someone does that, the agreement's not going to be valid. So let's talk about what makes agreements valid and not valid. There's really a two-pronged test for evaluating prenups. And this two-pronged test is also used to evaluate postnups and cohabitation agreements absent the closeness in time portion of it. So I'll tell you that in a minute. So first, the first prong of the test, and this is going to sound weird, but the first prong of the test is pretty much always failed. And that is whether the prenup is quote unquote fair. And that means, does the prenup follow exactly what a court would do if no prenup had been executed? Well, no, otherwise you probably wouldn't do it. The whole point of most prenups is to deviate from what a court would do and to have some certainty. So most prenuptial agreements fail the first prong of the test. That's just normal. Some prenups are determined fair, and if so, then the analysis stops there and the prenup is upheld. But for the most part, the whole point of the analysis is the second prong of the test, because if a prenup is deemed unfair, which is kind of the whole point, and when we say unfair, we don't mean it's totally not fair. You can have a prenup that you both feel is fair. It's what a court would do. That's what they think is fair, which is kind of funny, actually. It still may be upheld if it was entered into, quote unquote, knowingly and voluntarily. That's really the second part of the test. And there's a way that you find out if it's knowingly and voluntarily. As long as both spouses understand the rights that they're giving up, and as long as they aren't under like any undue pressure to sign it, like that whole week before or day before the prenup, then the court's probably going to uphold it. Practically speaking, entering into a prenup knowing and voluntarily means the following things, and this is well developed in Washington case law. First, Each party must have their own independent attorney. So let's talk about that. Usually someone will come to me and they'll say, I need a prenup. And I'll say, great. Do you want me to draft it? Or does your spouse already have another attorney drafting? And they'll be like, oh no, sometimes people will say, we just want you to draft it and we'll both work with you. Well, I can't do that because everybody needs their own attorney so they can get their own independent advice. What I'm going to tell somebody who's the primary breadwinner as far as what to propose for asset and debt division or what to propose for spousal maintenance is going to be different than I'm going to tell the person who's the financially disadvantaged spouse. You guys are not similarly situated, and an attorney can't ethically give advice to both people. Like, it doesn't work that way. So both people need an independent attorney. Usually one person drafts it, the other person reviews it, they send back edits. That's a whole process. It doesn't matter which attorney drafts it. I mean, anybody can draft it, but you need your own attorney then to review it if you're the non-drafting party. The second thing about knowing involuntary is the parties must conduct and document. This is very important. Active negotiations to show the agreement is truly bargained for. So what that means basically is if you have a prenup and you have it drafted. I have like 3 of them I'm working on right now where I will be looking at it and I'm saying, okay, I think this could look a little different. I think that could look a little different. And I am actively like suggesting edits, or the other attorney who didn't draft is suggesting edits, and we're negotiating for the agreement. It just shows that it wasn't forced on anybody and there was actual meaningful contemplation of whether the people wanted to enter into the agreement. So first, have your own attorney. 2, conduct and document active negotiations. 3, this is very important as well. Both parties must offer a full disclosure of debts of all assets and income. So if you're asking somebody to give up certain rights and you're asking them to enter into the agreement, you need to say what all the assets and debts that you are bringing into the marriage that you have are and what your income is. Otherwise, how can someone enter into an agreement? I've seen prenups where like the schedules on the end showing everyone's assets, one of them's empty. That's not going to be a valid agreement. It's just not. Oh, we forgot to fill it out, but we already know. It doesn't matter. It's not going to be a valid agreement. So that's important. And then finally, you must execute the prenup well in advance of the marriage itself to ensure that neither party feels pressured to sign out of fear that the impending marriage will be canceled. If you follow all 4 steps, the court will probably uphold the prenup. Then again, maybe it won't. It all sounds a little nebulous probably, and that's because it is. Basically, if your assigned judge doesn't like your prenup for whatever reason, they might try to find a way to throw it out. But for the most part, to make that outcome less likely and to avoid a one-sided prenup and affirm the agreement after the wedding, at the end of the day, you want to follow and make sure all of those things are done, and you want to make sure that that agreement is not rushed. I can't stress this to you enough. People will come and they'll say, oh my gosh, I need to get this done. I'm getting married in 2 weeks. And I'll tell them you have to do a postnup. I won't do a prenup for you because it won't be valid. So you have to really think about that. And if you're thinking about a prenup, the sooner that you plan ahead, the better. You might be wondering after this, like, is it even worth it to do a prenup? Well, yes. Despite with issues with enforcing them, and they're usually not enforced. The ones that aren't enforceable are usually because somebody downloaded it, someone didn't have an attorney, there's reasons why. But creating one is still a very good idea. Negotiating a prenuptial agreement, like I said, forces those kinds of conversations. And the reality is the vast majority of couples don't talk about what money's going to look like, and they don't understand like what that really means. You have to have conversations about, will both spouses work? Are you going to share incomes? Are you going to have separate accounts? How are you going to handle housing expenses? If 50-50 might sound fair, but what if one spouse makes a lot more money than the other? Is it really fair to split all the bills 50-50? Does it matter if we split all the bills 50-50? If one spouse has a 401k they're putting money into and the other spouse isn't working or can't afford to put money in, whose money is in the 401k? Who has an interest in that? All of these things are things that you talk about when you get divorced, but also when you do a prenuptial agreement. So you have a much better idea, what's going on. The questions get harder and harder. I mean, I could tell you many issues that come up. So you'll have to have those discussions when you do a prenup. One thing to know as well, when we talk about prenups, is you've heard me talk a lot about financials so far. Child support and custody terms in prenups are not enforceable. So custody is a wildly contentious topic during many divorces, as is child support. People might think, hey, I can preempt a custody battle and protect my parenting and visitation rights by including this in a prenup about how we'll handle the kids. But these type of terms are just specifically not enforceable in Washington. State laws do not allow child support and custody to be determined by a prenup. The courts, I tell people this, I was just telling someone this yesterday, a client, the court doesn't care what you do in your financial settlement. Like, they care if they're making the decision, but if you have an agreed settlement, you could give one party 90% of the property and the other person could say, I'm taking 10% and walking away. And the court's not going to be like, hey, that's not fair. If you agreed to it, you agreed to it. Court has no say to step in and mess with your financial settlement. When it comes to children, though, the court is the final authority. The court can refuse to enter a parenting plan that it doesn't think meets the best needs of the children. The court can refuse to enter a child support order that allows for no support for a child, or that allows child support that someone can't afford. The court actually has an interest, because the state of Washington will have to step in and help provide support if you don't when it comes to children, and there is an interest in protecting the safety of children. So you simply can't negotiate for those things. I will tell you this, I have done agreements in the past. Some people will insist where we put in there, this is what we'd like to do, this is what we hope we'll do, that we have big caveats in there that none of that is binding. And, I actually did have one case where we did a separation contract and the parties knew they were probably going to get divorced and were trying to work it out, and had said, we've been doing a 50-50 for the last 3 years that we've been separated, even though we're still married. We want to keep doing that. And that was one factor. Then when we did handle the divorce and one party tried to back away from that, it was actually a factor that the court considered. It wasn't determinative, though. So anyway, in general, you need to know in a prenup, you cannot deal with parenting and child support. The other reason why, too, is that child support is determined by the income of the parties at the time of the divorce. That can change. You could say, I'll pay you $1,000 a month, and then when you get divorced, you're not working and you can't do that. So anyway, other thing to know is that generic online templates, they typically don't suffice for prenups. Prenups are highly detailed. You might think you can Google one and do it that way, but they're specific legal contracts. They're not easy or simple to draft. It's also not a good idea to work with an attorney, in my opinion, that's not a family law attorney. The absolute worst agreements that I see are from like business or civil or contract attorneys, people who haven't litigated the validity of an agreement. And I'm not saying that so you call me to do your prenup, like I have more than enough prenups to do. But I'm telling you, find a family law attorney that does these. And the reason why is because we understand the ins and outs, and we understand the issues in a prenup. And we're going to talk about that next. Don't just go to somebody that has no idea about family law, because they'll give you an agreement and then me or another family law attorney will get it. And I'll be like, oh, and they missed this. And I'll have to go through and basically rewrite their agreement. So don't do that. Yeah, they mean well, but they just don't know because they haven't litigated these issues. So prenuptial agreements at this point, you might be thinking this sounds really negative. It might sound negative, but I'm trying to tell you maybe what you don't want to hear, which is take the time and energy to do it right. Before I talk about the issues that are going to be specifically addressed, Melissa, are there questions that you want me to answer?
Yeah, we do have a few questions. I think we could probably answer those real quick. I also just wanted to sort of chime in, and I really appreciate that you brought up the stigma around it earlier. I think that that's really important.
Yes.
And I know with many of the clients that I work with, that's been a thing. And it's definitely, people will say, well, I don't want to bet on my relationship to fail or things like that. But I really like how you kind of likened it to car insurance. It's a responsible decision to make to protect yourself, and knowing that we cannot predict the future. With all our best intentions, we cannot predict the future.
Yeah.
So thank you for that. I appreciate that. Coming over to the questions, somebody kind of two similar questions. Does a prenup outside of USA apply to Washington? Mm-hmm. And then kind of along those lines, if Washington has jurisdiction on outside country assets and marriage, then why would a prenup outside of the country not be taken into account? Can you kind of talk?
I don't know. Yeah, let's talk about that. A prenup, that's a great question. I've had prenups. Let me think. India, England, Chile once too. I've seen multiple foreign prenups, and yes, absolutely. This is really interesting too. It's kind of fun. For me, it's fun. Prenups can be valid depending on, even if they're out of the country or out of state. That's the other thing. Sometimes I'll get an attorney. I had an attorney not that long ago in New Jersey call me and be like, hey, I have a prenup and it was drafted in Washington. It's Washington prenup, but they're getting divorced in New Jersey. That happens all the time. Here is how that works. You could have a prenup that was done in Canada, and then the couple's getting divorced in Washington, or the couple's getting divorced in Oregon or whatever. What would happen is that prenup was valid, or whether that prenup is valid is going to be analyzed by the jurisdictional law where the prenup was drafted. So when I had an English prenup, we looked at what was the law and was it valid? And if it was, then it was valid here and those terms still controlled. So if you have a Washington prenup, like my New Jersey situation, that attorney was looking to say, like, what's the law on prenups in Washington? Is this going to be able to be upheld? Because they're going to have to look at whether the Washington court would uphold it, even though they're in New Jersey. That's the test for validity, because the New Jersey law would be probably totally different. And what would be the point of drafting an agreement with the security of having certain law apply if it changed when you moved? So it goes back to where you were from. But yes, you can have a foreign prenup or an out-of-state prenup, and it will be evaluated by that jurisdiction. And usually a prenup will say, not usually, it should, if it's a decent prenup, it'll say in there that the laws of the state of Washington or wherever will apply. So no matter where you are. So you don't lose the validity of your prenup when you move. So that's a great question, though. Mm-hmm.
Yeah, and then somebody else had asked about kids in custody and child support, and you already mentioned that it's not enforceable. Another question along those lines is how to handle monthly liability from previous child support that you need to pay for years from a previous marriage, or spousal support from a previous marriage. Can that be tied into the prenups?
Yeah, it can be. You're not legally obligated for those liabilities anyway, but I'll tell you this, it's a really, really, really important discussion to have. And the reason why is, it's like I was talking about earlier, if you're marrying somebody and they're paying a couple $1,000s a month in child support and expenses for another kid, you need to know that going in. That's not going to go away. And that I've seen so many times that be a resentment or an issue in marriages, or, oh, my money's going to pay for your kids. Like that, those kinds of things really do come up. And you very, very often I will include in agreements, because people talk about these things. It'll be like, oh, Jim has 2 children from a prior marriage. Mary won't be responsible for supporting them, although she endeavors to have a healthy relationship with them. Jim will pay his child support out of his separate property, or Jim will pay his child support out of his community property, whatever. Like, you will have to determine what's going to be community property and what's going to be separate property. And if there's separate liabilities like that, you're going to have to determine and know how that's going to be paid. And for most part, people pay child support out of their wages. And you might realize that's being paid out of this person's wages, and wages are community. So in effect, you are actually paying for part of their child support, and that's something that you need to understand. Or you can have an agreement where they pay it if they have separate property income, like from something else, but not everybody does. So yes, you can include that in your agreement, but it really is a bigger picture question about what's going to be separate and what's going to be community. Many people don't make wages community. Some people will say, my income's mine, your income's yours. It really just depends. Yeah.
Okay. Couple more questions here. If the future spouse doesn't agree to sign, is there any potential method to enforce?
No. No. And this is the thing too. These are why you have to have these conversations. If you are marrying somebody and they don't want to do a prenup and you do, maybe you need to really reevaluate what you're doing. I'm not saying don't get married, but think about it. You can't, number one, the whole idea of why prenups are disfavored is because the court doesn't want one person to feel pressured to do it. Mm-hmm. And if you have a spouse that doesn't want to define those things, which is fine. I mean, they don't have to, but you guys are probably not on the same page or ready to have those conversations. And maybe you need to think about it. I'm not saying you need a prenup to get married, but maybe you either need to be like, okay, this is where we're at. And you need to have those financial discussions. And if they don't want to do it and put it on paper, you can't do a prenup. Both parties have to knowingly and voluntarily enter into the agreement. If the other party is saying no, number one, if they're going to document you putting the hard squeeze on them, your prenup's not going to ever be valid. And number two, you can't force them to sign. And one person signing it doesn't do anything for you. So it might not be what you want to hear, but you guys really need to be on the same page about it, or there's no point in really pursuing it.
All right. And then one last question here before we move on to further content. Are there advantages to getting married somewhere else just because they have better prenup rules?
No, I mean, unless you think you know what's going to happen. I mean, no, nowhere is going to have nowhere is like, I love prenups and everything's going to be valid. No matter what, you're going to have to basically have the same basic validity. So no, I wouldn't say that you should forum shop and get married. And it's not where you get married either. It's where you reside. Like, I could travel to, Paris and get married there, and French law is not going to apply. It's going to apply if I lived in Washington. I mean, if you really want to move somewhere and live there and become a resident there just to take advantage of their laws, I mean, I guess you could, but I don't think that anybody would do that.
Okay. And then just lastly, can you back out of a prenup after signing?
I mean, generally, no. You signed a contract. I mean, if you don't have an attorney certify it, I mean, you can't really back out of it. No, if you signed it, you can't say I changed my mind. No, I mean, just like anything else, you signed a contract. You basically would have to sign something else saying both parties would have to agree that the contract's no longer valid. You're entering into a contract. Your signature means something. The negotiation for that document means something. No. So be careful.
Okay, I don't have any open questions now.
Okay, perfect. Thank you. So a couple things to think about as we talk about the kinds of issues, before we talk about the kinds of issues that are important. Prenups, let's talk about what those are. Let's just do it because it's already, I think we're halfway into this. Prenups deal with community property most of the time, and they deal with spousal maintenance most of the time. They also likely deal with who's going to pay attorney fees in the event of a divorce. They also deal with what is called a committed intimate relationship waiver or a lack of waiver ahead of time. And let's talk about that because this is going to jive with cohabitation agreements. Let's talk about committed intimate relationships and why that matters in your prenup or why it would matter with cohabitation agreement. I told you this before, but living with somebody in Washington has different connotations potentially than other states do. So if you live with someone and you stay in what is called a committed intimate relationship, which is something that has to be proven in court, but basically the hallmarks are, did you live together in an exclusive relationship? Was it not a roommate relationship? It was an intimate relationship. Did you pool resources to support each other? Was it a marriage-like relationship? Was it a close relationship? If you got married and you continuously lived together, most of the time the court's going to be like, well, of course it was. They eventually got married. So if you lived together for around 2 years or more, and got married or didn't and broke up. I've had some committed intimate relationships. People lived together for 20 years and never got married. Well, community-like property attaches when you begin cohabitating. So you could live with someone for 5 years and you're working at Amazon and you've got a bunch of restricted stock units and you put money in a 401k and the other person's like a barista at Starbucks and they don't have anywhere close to what you have. And then the relationship ends and that person could go and file for dissolution of committed intimate relationship and say, hey, we were in this relationship and all property that was earned during that relationship should be divided. And guess what? You got a real problem then, because that is something that can happen. And proving a committed intimate relationship isn't a given, but it's also not especially difficult if you truly were in one. So a cohabitation agreement can say, no, our wages are not community. No, our retirement's not community-like. No, none of these things apply. And we are just living together for the purposes of companionship, and we are not going to have any property rights between us. You can do that in a cohabitation agreement. Why does that also matter in a prenup, though? I'll tell you why. And I've seen this really blow up on people at different times. If you are in a situation where you live together, because this is the thing, most people live together before they get married. You just do. And I think that's a good thing. I mean, that's another thing the data bears is that if you live together for 24 months or more, the odds are better that your marriage is going to work out because you know what you're getting into. But anyway, if you live together beforehand, you might think my prenup starts when I get married. And maybe that's true. But what if you lived together for 5 years beforehand and one person earned a lot of money during that time while you were together? That money that was earned while you were together and their job or those bonuses they got or all of those things, you would be, if you're trying to have an agreement that says we are now calling that all my separate property, an attorney is going to tell the other party, well, no, you have a potential interest in that you are giving up by entering into this agreement. So a prenup will need to deal with how do we treat that pre-marriage cohabitation period? I get these all the time from other attorneys that don't do family law and they won't even address it. And I'll be like, well, this is kind of a big issue. And they're like, I don't know what you're talking about. And then we tell them and they're like, oh, so I tell the client, I'm saying, well, you lived with this person a really long time and I had one person that actually started like a successful dental practice during that time, and it was worth a couple $1 million. And the person who was the dentist is saying, well, our community only starts when we get married. The other person's like, no, it doesn't. We've been together all this time and that's all community. Those can be real issues. So you have to deal with the cohabitation period before the marriage when you enter a prenup. Are you going to waive it and say everything is separate coming in, or are you going to want to evaluate it and say, no, our community started earlier? That's very important. In a cohabitation agreement, that's the whole point. The whole point is to determine what are the rights and liabilities when we enter into this agreement to live together. Cohabitation agreement also will become invalid if you get married, so you'll need to convert it to a prenup, and different things may apply. So that's very important. Last thing, because this is not a committed intimate relationship webinar, but the last thing I will say about it is the two main differences. If you are in a committed intimate relationship and property is divided, two things that you get in a marriage you don't get in a CIR, as we call them. One, you cannot get spousal maintenance. Two, you cannot get attorney fees awarded. All you can get is division of debts and assets. But anyway, still, it needs to be dealt with in any prenup, and that's the whole point of a cohabitation agreement. If you don't have one, yes.
Oh, I just keep going. I just wanted to there was a question here about cohabitation. If you can just maybe seek to clarify one more time. Just, they're asking, and it's not just anyone living together, right? If you're in an apartment with room sharing or helping our friends.
It's a committed intimate relationship. If you're not committed and you're not and it's not intimate and it's not a marriage-like relationship, if you're just hanging out with roommates, that you live with for several years, you don't have a committed intimate relationship with most of them. So no.
Okay.
Yeah. So anyway, that's why it's really important. You could live with someone and not realize this is happening. So it'd be a good idea for you to talk about a cohabitation agreement if you're moving in with a partner. And you'll need to deal with it in your prenup. Okay. The next thing you'll need to deal with in your prenup is the biggest issue is community property and separate property. Separate property is anything that you bring into a marriage, and it could be from that committed intimate relationship period, but let's just assume it's not for sake of discussion. Anything that you bring in, you'll need to disclose. So if you have money from inheritance, if you have money from a second your job from before, if you're later in life marriage and you've already well established and you have, rental properties and you have a home, all of that is your separate property coming in. And so you will need to disclose it and decide that you're keeping it separate. You also, the character of property, whether it's separate or community means we both have an interest. Separate means it's mine. That is determined at the time the asset is acquired. That can change if you commingle an asset and everybody starts spending and you put 100,000 of an inheritance in a joint account and other money's coming in and out, and that's gone, right? That's commingling, long and short of it. Or through transmuting an asset. The most common thing is transmutation of like real property. I own a home, for example, let's say, and it's my home. I owned it before I ever met my husband, and I put the down payment and he just came and lived here. And then I went to refinance it. And after we were married, I was like, oh, I'm going to refinance it and I'm going to put you on the title. I've changed the character of the property by putting him on the title. And I did that and made it community. I transmuted it with a writing. That's different than commingling. That's the two ways you can change the character of property: commingling and transmutation. There's more to it than that, but that's a high level overview. So you have those separate assets that you bring in. You're going to need to clarify what those are. You've protected them now in a prenup. Cool. Then you have what you're going to earn during the marriage and how you're going to treat that. So your community, let's say for sake of discussion, starts when you get married and it ends when you get separated, if you ever do. So during the community, there is a presumption that wages, anything you earn and anything that you do with those wages, any asset that you acquire at all during the marriage is presumed to be community, which means both parties have an interest and it can be divided. You can decide in a prenup that's not the case. You can have a common prenup for people that are similarly situated is very often what we call a name on title controls agreement, where name on title actually controls everything in my name is mine, everything in your name is yours. The only community property is going to be what we actually put both of our names on. That's not how the law works. So if you want to do that to keep things very clear, you can, and that's becoming more and more popular. But you'd also have to be aware that if there's going to be only intentionally created community, are there going to be requirements in your prenup to say that we are going to create community? Is it going to be that each party puts in, 50% of their wages into the community account every month? Is it going to be that there are mandatory community, contributions to an account or not? Or is it just going to be, there's a lot of things you can do. Or is it going to be that all wages after tax are community? Is it going to be that our retirement accounts are community or not? I mean, all these decisions have to be made, how you're going to treat your assets. a lot of people will say, yes, we really want everything to be community. We really just wanted to do this to protect everything we were bringing in, right? Or they might want to say, oh, 75% of our money is community, but I still have that right to grow my own separate estate with 25% of it. There's so many things you can do. So this is just like throwing things at you so you get the point that there's a lot of different things you can do. You're going to decide what's community, and then you're going to decide how to divide it. So the whole idea about what's community is an ongoing discussion that you have before you draft. Then you decide how to divide it. I can't stress to you enough that Washington is not a 50-50 state. What that means is community property is not automatically divided 50-50. You might hear community and think we split it equally. No, wrong, not the case. The standard for dividing community property in Washington is a just and equitable division. So what that means is once you know what's community, the court will look at different things like how long you've been married and what the financial situation is of the parties. Like what's your story in your marriage at the time of division? If you had a 20-year marriage and you had a stay-at-home spouse and a working spouse, the stay-at-home spouse is going to get 60%, maybe even more of the community because they're not going to recover financially as fast from the divorce. On the other hand, if you're married 3 years, that's a short-term marriage and nobody's been in the marriage long enough to rely on it. So the principle there is to put the parties back where they started, and it probably is going to be a 50-50 division. So it really depends on the story of your marriage. But throw all that out the window, and in your prenup or your postnup, you get to decide how you're going to divide it. Is it going to be 50-50? Is it going to be if one party makes X amount more than the other party, it's a disproportionate division? What are you going to decide on? A lot of the time people will want to say 50-50, but you have one person that's going to make $500,000 a year and the other person that's never going to make more than $100,000 a year. Well, 50-50 is not equitable for the lower earner. So they might not want to agree. It'd be a home run for the other person. So it's not always what it seems, but you'll have to decide what is community and how do we divide it? And is there going to be any community? Okay. And what is separate? Those decisions will all have to be made in a prenup. Is there anything else before I start talking about maintenance?
Yep. We do have quite a few questions that just popped in here. Okay. One question here. They're asking, what is the validity of any handwritten documents about assets in Washington? Are they admissible?
What does that mean, admissible?
I mean, I guess they're just saying if it's not, maybe two people hand wrote something.
No, it's probably not going to be. If you're calling that a prenup, it's probably not going to be valid.
Yeah.
If you have a contract, like if you're trying to contract, then you're talking about contract law outside of a prenup, maybe, but then we'd have to have a whole other discussion on the elements of a contract. Like that's a whole other thing. Just because it's handwritten doesn't mean it's not going to be valid, but I don't know anybody that would reputably write up a prenup. What I do see is one person writing and being like, sign this. That's not going to be valid.
Right. Number of questions about community, property, and cohab. This question asks, if you're in a marriage and get an inheritance from parents after they die, is that community? What's Washington law without a prenup about inheritance?
Inheritance is by definition of law separate property. But here's the thing to know. It's very important to spell that out in your prenup too. But is the gifts are the same. Is the gift or prenup specifically given to you? If your parents left you money specifically, then it's yours. But you must keep it in a separate account, your name only. If you put it in a general account and then other money goes in there and you're spending it, it's gone or it's completely gone. So don't do that. If you had no prenup, yes, it's yours as long as you protect it and don't commingle it and it's not gone beyond recognition. Gifts are the same. I had a case a few years ago where it was a great case actually. And the parties owned a house, right? And they bought the house together. They were both on title for the house. And then the father of my client gifted her payoff of the mortgage. So he basically wrote her a card and said, what do you give a great daughter? How about a house? I am paying off the mortgage. And the mortgage was basically everything they owed on the house for the most part, like that they had even put into the house. So the husband's name's on title, but the gift was specifically to her. So then they get divorced and she's like, well, the house is mine because all the money's mine. And you know what? She wasn't wrong. The house by character was community, but she had a separate property interest that was gifted to her that was all her separate property. So she basically got all the interest in the house. So if it's given to you only, that is important. I had a case not that long ago too, where the client is like, well, my parents gift me money every year. They gift me this 40,000 every year, and I'm putting it in this account. And I was like, great, you're protecting it. It's going in your own account. But then the other side was like, well, no, it was gifted to both of them. And it turns out that the checks were written to the husband and the wife, and the husband was just like signing both of their names and putting them in his account. And it doesn't matter. That was a gift to both of them. So you have to be really, really clear about that. And sometimes if you've been married a while, your parents love you both and they're giving it to both of you. But in an inheritance situation, it's usually only left to one person. And you want to protect that by keeping that money segregated in your own account and not commingling it.
Okay. Few more questions about cohabitation. If you cohabitate for a year and then you move out and get everything separate, but you're still dating afterwards, was there ever a CIR?
A year's not really long enough for a CIR. I'd say if you get close, you get around 2 years. That's where we're talking. If you move out, and cohabitation is the hallmark of a CIR. You can be dating somebody for 10 years and not live together, and you're not going to have to worry about a CIR.
And along those lines, so if we both have our own homes, but we stay at each other's place 50-50, when does cohabitation start? Okay.
Not a CIR, no. If somebody maintains another apartment, even if they're always at your house, you don't live together. You're not pooling resources for a residence or anything.
Yeah, similar question. If a married couple never lived together, even though they were together for 12 years, if they're married though.
If you're married, it doesn't matter if you live together. It's community.
Okay, so community property.
If you're married, then community property applies. I have had clients where, for professional reasons or whatever, or taking care of family, people live apart for years, but they're still married. So yeah, that's different. That's different than if you're just dating and not living together, because you have the legally binding marriage. You have to prove a committed intimate relationship, and you need to cohabitate for that.
Right. And then a prenup, unless it's defined in the prenup itself, there's nothing that has anything to do with the dependency of how long the marriage was, right? Unless people spell that out.
Oh yeah. Yeah. That's usually is spelled out.
Yes.
Yes. Yeah. I mean, a prenup, you can't say, oh, if we're married for this long, but a very common thing in a prenup I talk to my clients about is a sunset provision. A sunset provision means a part of the agreement will sunset, will end, or the whole agreement will end. And so you might have a situation where one party has a lot of separate property and the other party doesn't. And the separate property is all separate unless they're married for 25 years or more. And then the separate property provision sunsets and everything becomes community. And the reason someone might want to do something like that is because if you didn't have an agreement, the court's going to look at all property anyway if you've been married that long in a long-term marriage. So there's not a lot of motivation for someone else to sign an agreement unless there's a sunset at some point if someone has no separate property. Lots of discussions could happen, but there can be limits too. If we're married for this many years, then this applies. If we're married for this many years, then this applies. It's really a choose your own adventure. You can do whatever you want, but terms based on length of marriage are not uncommon at all. You can definitely do that. It's also common with spousal maintenance where it could be like, if we're married for this long and this happens, someone stays home with kids, then this applies. If someone then goes back to work for 2 years, then it sunsets. Like there can be a lot of different things that you can do.
Okay. What about gifts? You talked about gifts earlier. What about gifts from spouse to spouse? Is that community necessarily, or?
If someone's gifting separate property to their spouse, then now it becomes their spouse's property. I always have a provision in my agreements, almost everybody that does a decent agreement does, that says nothing in here prohibits gifts to spouse. But you should know this. So if I gifted my husband a really expensive watch and I bought it from my separate money, but I gave it to him, if we get divorced, I might be like, I want that back, or I want that to be divided. No, I gifted it to him. It's his separate property. It's this same thing like with a wedding ring. If you have a wedding ring and it's given to you and you get divorced and the other person's like, I want that back. Well, no, it was given to you in contemplation of marriage. The marriage was completed. So I fulfilled my deal. I get to keep the ring, right? The only exception to that is if it's an heirloom. There is specific case law in Washington that says the heirloom, that part of it needs to be given back. So if someone gave me their grandma's ring and then we got divorced and they're like, I want it back to family heirloom, I got to give it back.
But otherwise, if gifts are purchased from the community, what's the law around that? Just somebody's asking for clarification.
If someone's gift purchased from the community, well, I mean, if the gift is purchased from the community and it was given to one, that's usually what happens. Yeah. It's given to one person. Then if you get divorced, well, it was given to me, it's mine. It's your separate property. You get to keep it.
Okay.
Yeah, it doesn't matter where the money came from to buy it. Usually it's someone getting like ticked off because they spent separate property on it. If you spent community and it was given to one person, like if I took community money and I bought my husband a car for Christmas, or even just like a watch or a jacket or something, whether it's big or small, he gets to keep it. It doesn't matter that it was community money.
Okay. And then if they have a prenup and the spouse still tries to go to court over it, who pays for the attorney fees?
That usually is spelled out in the prenup. And a lot of times someone will try to go to court over it. And a smart prenup has a dispute resolution provision too. I like to put in there that arbitration will be used, binding arbitration will be used. That way, the whole idea of a prenup is to avoid court. So if you go arbitration, it's a lot. You have an arbitrator decide on the validity of it. If someone's trying to challenge it, that's a lot more fast and it's more cost effective. But typically it'll say two things about attorney fees. One, if the community is going to pay any fees, or if everybody's going to pay their own fees, or if you have a really financially lopsided situation, it might be that person A pays a certain number of fees for person B. But very often it'll be like if someone's challenging the validity of the prenup and they lose, then they pay the other person's fees. So the prevailing party will win. You can do all of that should be dictated in your agreement.
Right. Great. Lots of great questions. It looks like we've cleared them for now.
All right. I don't have a lot of time, so I'm going to touch on the last few things that are that need to be in a prenup. Spousal maintenance, it needs to be in a prenup. I've had agreements. I had one, this was a few years back now, where everything was addressed but maintenance. And I was kind of like, well, what's the point? Because we had everything addressed, but we still ended up like going to an all-day mediation just to fight about the maintenance. It's kind of like, I didn't get it. And you kind of need to determine how you're going to divide community property and maintenance, excuse me, together. And the reason you're going to do that is because it's part of your overall like financial settlement. Maintenance is what we call, Washington courts call, a flexible tool to do equity, to determine what's fair. So if you already decided your property and you haven't decided maintenance, you kind of need to decide them together. That's just the best way I can put it. So you'll need to decide whether there is spousal maintenance. If there is it going to apply automatically? Who is it going to apply to? Is there going to be a ratio based on number of years of marriage equals number of years of maintenance? It's usually somewhere 3 or 4 years of marriage is 1 year of maintenance. Is that going to apply? Are you going to agree to something more? Are you going to say maintenance is waived completely? If you're going to do that, you need to be very careful too about whether you want a disability waiver. If you have just nobody's going to pay maintenance, I'm sorry, you say nobody's going to pay maintenance, that's great. But if you don't mention that the parties have contemplated possible disability or incapacity, then what's going to happen is if somebody's disabled or whatever, maintenance is still going to apply. You have to actually contemplate if you're doing a total waiver or just a partial waiver. If you're not doing a waiver, is maintenance automatic, like I said, or is it triggered if one party stays home for a while, or if there's a certain amount of discrepancy in income? A lot of different tools can apply. How do you figure these things out? You talk to an attorney and they make suggestions based on your situation. That's how, because this can all sound very overwhelming, but it's really not as overwhelming as I'm probably making it sound by telling you all the things you have to decide. That's why you don't do this on your own, because you don't know what to decide. So anyway, so we've talked about the fact that you'll have to decide community property. What is community? How to divide it? What is separate brought in, if that's going to stay separate? And then what is going to be separate during the marriage, if anything? You're going to need to decide maintenance, if it applies, when, how much, to who, what's the ratio? Does it sunset or stop at a certain point? You're going to need to decide how to deal with attorney fees. We talked about that a little bit as well. You're going to need to decide what happens if one spouse starts a business during the marriage or is a business owner. If you have business owner implications, is just the reasonable salary from the business going to be community property, or are the other profits from the business going to be community property as well, depending on how the business is set up? All kinds of things like that. You're going to need to talk about how to deal with, and this goes to the debts and assets, but specifically real property purchased before the marriage, or real property purchased during the marriage. One thing that's very common, one of the last things I'll touch on, because it comes up all the time in agreements and in divorce, is you have something you're both on, name is on title, you both bought it, it's community, but one person used $150,000 of separate property money on the down payment. The other person didn't pay anything, or they only paid $10,000. How does that play into dealing with the property when you get divorced? Are people getting their down payment back? Are they owning the home proportionally? What happens? So all of that is stuff that you'll decide in a prenup too, how to treat real property. Most important thing I can say say, as we get ready to wrap up and see if there's any last questions, is that do not wait. Do not wait and tell me you're getting married in 30 days and you want a prenup right now. You're not gonna have time. Like, you're gonna have to do it as a postnup, and you're gonna then be dealing with this while you're getting ready for a wedding. No, plan well in advance. I typically don't like to do a prenup for someone if we can't complete it 60 days before the wedding. It's just better for you. It's better for your marriage. It's better for the validity of the contract. 30 is the bare minimum, in my opinion. And that means to have the agreement fully done and executed, not just start working on it then. So if you want to do it well in advance, and be on the same page as your partner, and look at it as an opportunity to have some of those discussions that are going to set you up in the future. So I hope that this has been helpful for you. If you have other questions, feel free to reach out. Melissa, I'll just see if there's any last questions before we log off.
There's a couple of last questions. We'll see if we can just maybe answer 2 of them quickly, and then we'll go ahead and wrap up here. Yeah. Just asking, are post-cohab agreements valid for the entire CIR?
I'm not sure what that means.
I'm not sure if I can interpret it either.
Hang on, let me think about it for a minute. Post-cohab agreements?
Yeah.
Like I think this person means if you do a cohabitation agreement and it says there's no CIR and you determine how you're going to spend assets and liabilities, is that valid? I mean, yeah, that's the point of a cohabitation agreement, I think.
Yeah, I think
you
so.
have to make sure it's valid.
Yeah. Let's see, if you start an LLC, is the entire valuation of the business split, or just the salary paid to you if you're in a CIR or married?
It depends on, number one, if you're in a CIR or if you're married, and it depends. Number 2, you have an LLC. An LLC is just a piece of paper. Are you incorporated? Are you a C Corp? Are you an S Corp? Are you being paid on a K1 that's a pass through? I could ask you so many questions. So in general, all wages are a community without an agreement. So you probably, and the reason I ask is, in a CIR situation, if you're both not on it and it's very clearly separate, use separate funds to start, you might be able to say, even if we do have a CIR, this is completely wholly separate interest, and maybe only the wages would be treated as community. There's so much speculation here, though, that you really need to talk to somebody about your situation if you're looking at business interests.
Yeah. So with that said, thanks so much for coming to the webinar today. Putting up a contact slide here in case you would like to contact the law group, or if you or someone that you know is interested in counseling service, you're welcome to contact me as well. Yeah, so come again. We have webinars here monthly. Lots of different great topics are covered.
Melissa, we should mention, I'll mention this. Yeah, thanks for coming. I think one thing that's really important, I'll just put this out there for you. 2 things, actually. One is that a lot of people, whether it's about a prenup or a divorce or whatever it is, they take a long time to take action because these are difficult topics to talk about with your spouse. If you've come to this webinar today, and a good number of people I think did, you had the opportunity to get information and to kind of start to think about it. And you've already taken a big step that a lot of people never take. So that's good. The more information that you can get is better. So you should feel good about getting information. You're already ahead of a lot of people that don't want to talk about these things. But the other thing I was going to say is that Melissa mentioned we do these every month on different topics. We also host a meetup group. It's through the meetup.com platform, and it's also information's available on our website as well. And really, it's a divorce and separation meetup. So you could come and ask about prenups, but a lot of people are asking a lot of questions. Anyway, it's a forum where we do them in person, but we also do them on Zoom. And I just thought of it because we have one next week on Zoom, where if you want to come back and ask more questions, it's me, Melissa will be there. We have a certified divorce financial analyst there. We have a real estate divorce specialist there. We have a lender there. It's all kinds of, we have a little team, and you can come and ask us questions as well. And I will do my best, and they will do their best to answer them. So just keep getting information, no matter what your situation is. Information puts you ahead of the curve, and just don't hide from things or avoid them. Those are the people that come to me and they're like, oh, I'm getting married in 2 weeks. I need a prenup. And I'm like, no. So anyway, you're ahead of the curve by coming to this. Thanks so much. I hope you have a nice day. Bye-bye.
Thanks, everyone. Take care.